we will likely see further mutations, some of which our current vaccines may not be able to protect against, and have to reinforce some of the restrictions that have come to infamously define much of 2020.
Chicago recording an average of 90 new cases a day. The CDC says the Delta variant now makes up 83% of COVID cases. That's a big jump in less than a week. A day after sharp declines, a major rebound on Wall Street, just about erasing most of what was lost. Arrested the chairman of President Trump's inaugural committee.
At the 2016 Republican convention, Tom Barrack made no attempt to hide his longtime association with Donald Trump.
I'm here because Donald Trump is one of my closest friends for 40 years.
That relationship may put him in prison. In 2016, federal prosecutors in Brooklyn said Barrack made himself the conduit between the Trump campaign and the United Arab Emirates. Court records said he pushed UAE interests, even provided Emirati officials with a draft of a Trump energy speech and solicited feedback. Barrack is charged with unregistered lobbying and then lying about it to the FBI. Aaron Katursky, ABC News, New York.
The accused San Diego synagogue shooter pleads guilty to state murder charges. John Earnest agrees to life in prison without the chance of parole, plus another 137 years. ABC News has learned that 11 Republicans in the bipartisan infrastructure negotiating group tell Senate Majority Leader Chuck Schumer none will vote to start debate on a bill Wednesday, but they do support starting debate Monday. You're listening to ABC News.
From the KMET Weather Center, for Beaumont, Fanning, and the Pass area. For this afternoon, sunshine, a bit of a breeze, high temperature 98. A mainly clear night tonight, low 72. Wednesday is going to be mostly sunny, high near 100. For Redlands this afternoon, we'll see plenty of sunshine with a high of 98. And for Palm Springs, it's going to be a sunny, hot afternoon, high 110. I'm meteorologist Jim Minaldi for Smart Talk 1490, KMET.
Take KMET 1490 AM with you everywhere you go by downloading our free smartphone apps found on the KMET website, KMET1490am.com. You can also go to the Google Play Store or the Apple App Store on your phone to download the free app. Now you can listen live or play any of your favorite programmers' podcasts using your smartphone. Go to KMET1490am.com and download your free phone app today.
The following is a paid program. Views and claims expressed are those of the program producer and are not endorsed by this station. Opinions expressed are not necessarily those of radio station KMET, its management, employees, or affiliates. The WK Law Power Hour is here to take you from zero to hero in legal knowledge in 60 minutes. A law firm with 40 years of experience is ready to give you legal guidance you need for free. What could be better than that? Amazing stories about actual cases. Interesting and informative guests. Listen, watch, call in. Come ready to learn. And now your host for WK Law Power Hour, Paul Wallin.
Hi, everybody. This is Paul Wallin, senior partner of Wallin Klarich, and your host for the WK Law Power Hour. This is our 10th show, and for 10 weeks, we've been bringing you tremendous legal information about local issues, national issues, and giving you answers to questions that you need to have the legal power you need to face the challenges that we all face in 2021. I've been a lawyer for over 40 years. I have a successful law firm, and the entire reason I started this program is because too many people, unfortunately, are just uneducated about national legal issues and local legal issues. Hundreds of people plead guilty to traffic tickets, pay fines, increase their insurance because they don't know crap about how to defend a traffic ticket. People going through divorces don't call a lawyer to get advice until it's too late when they might lose custody of their children. People facing a DUI. They ask their friends who might have had a DUI and probably did jail time instead of just picking up the phone and calling a lawyer. I don't care if you call Wallin and Klarich, although we're damn good. Just call someone. The purpose of this show is to answer your questions and to bring on really, really intelligent people to talk about the law and what they do and how they can help you. And if you want to call us, for us to answer one of your questions today, call 951-922-3532. That's 951-922-3532. Also, if you're watching this show on TikTok, which is cool, just send a question in Obviously, because my guest is a brilliant criminal defense attorney, try to make the question something that you're really interested in about criminal law. Murder, child molest, rape, robbery, drunk driving, traffic tickets, anything. Because we'll be here to answer your questions. But what's really important is that people understand that if they're facing a legal problem, they should not face it alone. So every week I also talk about some things that are in the news that relates to the law. And today I want to talk for a few minutes right now about the Delta virus and the law. And what can the law do to help people not die? There are too many ignorant people, uneducated people, or people that have been swayed somehow by certain crazies that this virus is not going to be solved by the vaccine. Young people are getting very sick, and some are dying because of that stupidity. So UC campuses in California and state colleges have told students, you don't get a vaccine, you don't come on our campus. And what is that going to do? It's going to save lives. It's going to save people put on machines. More people need to step up and not be worried about violating the law, because I think they'll be supported by telling people you can't go on campus, you can't go to this football game, you can't go unless you are vaccinated or you wear a mask. And please spread the word, because if we can accomplish saving one life, putting one person not on a machine, the tears, the funerals, then it's all worth it, taking that risk. So there are many, many legal things going on right now. But as far as I'm concerned, there's so many legal issues going on. But the one that is now on the table to save lives is whether it is legal for a company to tell an employee, you cannot come to work unless you're vaccinated. So guess what? If you tell an employee, let's say you have all your employees but 2 are vaccinated, and you decide to tell the 2 that aren't vaccinated, you're going to have to work from home, and they want to sue you. You know what I say? Sue me. By the time you get to court, it'll be 3 years. In the meantime, the virus will be over. I saved the people that come to my office from getting sick or dying. And if other employers had the balls that we do, then there would be less of this virus spread around. I beg people that are listening to the show or watching me on TikTok to have the balls to spread this message that you can stand up. And even though I'm a law firm, I'm telling you, there's no law that says you can't do that right now. Let a Supreme Court justice say that. Anyway, I'm telling you guys this because I have friends that are now mourning the loss of a loved one because of this. And when I read people on other news stations saying it's a hoax, or all the other stuff you might read on all these followers following me on TikTok today, and you read this garbage, it's not real. Follow the science. And after the break, you guys are going to have the great honor of being able to hear and listen to Matt Wallin, who is not only a brilliant lawyer, but he's my son. And he's been brilliant since I coached him in basketball when he was 5 years old, and he's equally brilliant now. So after the break and some commercials, Matt Wallin will be here answering great questions, and feel free to call in and go to break.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
Hey, are you okay to drive?
Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV and court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
When you have a warrant for your arrest, it's a very scary time in your life. When you drive a car, you have to be extra careful that you do not commit any sort of moving violation. You have to be looking over your shoulder, checking for police officers. Will you be stopped and thrown in jail? What a horrible feeling. For over 40 years, we have helped thousands of persons resolve their problem with having a warrant. In some cases, we can actually appear in court for you without you being present to recall the warrant. Depending on the facts of your case, you may never have to do 1 minute in jail. Stop living in fear. Call us now for a free phone consultation at 877-4-NO-JAIL. That is 877-4-NO-JAIL. Or go to wklaw.com. Isn't it time to get your life back? We will be there when you call.
We're back. And it's Matt Wallin of Wallin Klarich, a partner, one of the most brilliant lawyers I know, and also my son. So I'm not biased at all. And he's here for the whole hour to talk about his background, his career, what got him to become a lawyer in the first place, and to answer your questions and many of my questions about how you should face a criminal charge. What should you do when you are accused of a crime and get the help you need? So, Matt, good afternoon. How you doing?
Good afternoon. Thanks for having me.
No problem. Can you tell me, first of all, how long you've been a lawyer?
This is 11 years, close to 12.
Wow. That's hard for me to believe. I don't know if it's hard for you to believe, but it's very hard for me to believe. Because I still remember you in that T-ball outfit. Can you tell me what made you decide to become a lawyer? What was the reasons behind becoming a lawyer in general?
Yeah, I wish I could pinpoint exactly what led me down that path. I think it was probably a combination of things. Growing up with lawyers in the family, you obviously had influence over that. My older brother, Mike, was also an attorney. I was just drawn towards being an attorney and trying to advocate and help people. And I wasn't exactly clear on what type of law, but that's what really led me to law school, knowing that I wanted to become an attorney, and things developed from there.
Where did you go to undergrad and where did you go to law school?
I went to UC Santa Barbara, and then I went to Chapman Law School in Orange County.
Okay. Did you think that was a good law school? Do you get a good education?
At the time that I went to law school, there really weren't many options in Orange County. I knew I wanted to stay local because I wanted to practice locally after. UCI was not even in existence at that time, so my options were limited. But I was happy with Chapman. It was close to where I lived, where I wanted to practice, and I had a great experience.
Okay. And when you graduated law school and you passed the bar, thank God, because that's not so easy in California, let me assure you, and it wasn't easy for any of us going through it with either my older son or my younger son. I relived the experience that I still had nightmares about when I took it decades before. But when you passed the bar, you came to work at our law firm, right?
I mean, technically, I was working at the law firm in like a legal assistant or law clerk capacity back in college, which was, in the 2000s. So really, it's been 20 years that I've been a part of the firm. But yes, after I passed the bar and I was actually licensed, I started working for the firm. So it's really 11, almost 12 years with the firm as an attorney.
Kelly, how you doing? Welcome to the show.
Hello.
Hi, what question can we answer for you today?
Yes, I was saying, so recently my uncle has been arrested because a 5-year-old kindergarten student said he touched her. He's been a school teacher for 15 years, and now he's suspended from teaching and is facing many years in prison. Is there anything you could do for him?
Matt, why don't you answer that question the best you can?
There's a lot to unpack there. Starting point is when you say he's been accused, how so? Who did he or she, the student, disclose to?
I apologize. What's the question again?
Who did the 5-year-old disclose to or tell that this occurred?
Yeah, so he told his parents, and his parents filed a police report.
Okay. And is law enforcement already involved in terms of they tried to contact, is it your stepfather?
Yeah,
he's
so
arrested,
he's been arrested.
Okay. So step one would be for us to go meet with him in custody and in confidence discuss the allegations, the facts, and then reach out to the DA's office and figure out where they are in the process of filing formal charges.
I see.
And then after that happens, well, obviously if your family wanted to hire us, of course, then of course we would do everything in our power to, assuming he denies the charges, we'll do everything in our power to try to get the charges dismissed, which means, but it's going to be a very long battle because this kind of crime of a 5-year-old in California, what's the penalty, Matt, if you are convicted of that?
Potentially life, depending on what's being alleged due to the age. But again, without knowing more of the details, it's hard to really dissect how we'd approach it. We'd have to run our own investigation parallel to what law enforcement is doing, ask questions, and figure out if we couldn't stop the process in its tracks. But we'd have to start from the bottom and work all the way through.
And he's going to probably be in jail on extremely high bail because I think the bail schedule is like $1 million when you allegedly molest a child under 10. And it's so different than it was when I started practicing law. This is basically a life or death situation just about, and I'm so sorry your family's going to be going through it. But what I suggest, it's totally free. Just write down 877-466-5245. That's a toll-free number. You can ask to speak to Matt or myself or any of our lawyers who do this, and we can take your family through the process. So we know right now the biggest anxiety your family's feeling, of course, is the unknown. Oh my God, how could this be happening? Oh my God, will he ever get out of prison? What are we going to do? Can we afford a lawyer? By talking to a lawyer confidentially, it will at least give these people, your family, the knowledge that they need to then know which is the best option. And it will lower the tension a bit. Does that make sense?
Yes, it does. Thank you so much. I'll make sure to call into the law firm.
Okay. Thank you very much for the call.
Take care.
Thank you very much. Take care. And just so everyone listening knows, this is the kind of thing that happens every single day, many times a day. Families call. They know nothing about the system. They don't have a clue how serious this is. And we'll go into it later in the show. But the penalties for child molestation in California are so horrible. And the thing is, if the person denies the charge and he's convicted, a wrongfully convicted person can go to prison for the rest of his life.
There's
And
no
of
middle
course,
ground. There's
there's no middle ground.
And if someone's denying the accusations and they're facing life, it's difficult to find a middle ground in terms of a resolution in a case like that.
Yeah. So Matt, going back to your own story. So when you were in law school, I know you had worked in our firm as a law clerk and you got to know it. But What was it about criminal defense that you decided, I'm going to stick with it after I pass, as opposed to any of the other areas of law? Why did you pick criminal defense?
I think the key for me was I had a lot of different mentors that were already practicing as criminal defense attorneys. So I got to see, I got to get outside the distraction and the noise of law school, which can really distract you from what you're ultimately going to be doing when you practice. So I was able to separate my studies during law school and realizing that's just a process, and learn by going to court and shadowing other attorneys, seeing them negotiating cases, meeting with prosecutors. And I guess that's when I got hooked on thinking this might be a good fit for me, given my skill set in terms of representing my own clients.
How important do you think it is, whether it's you or any young lawyer, to be able to do exactly what you did? Who, let's say they just passed the bar and they have the opportunity for a year or 6 months to shadow a criminal defense attorney from the minute that a client is calling on the phone to the client consultation and go to court with them. How important is that?
I mean, as important as it gets, assuming that it can be had, that opportunity is priceless. It doesn't have to be criminal defense. Any area of law that you're thinking about exploring, it's very likely that whatever you learned in law school by way of the cases or the statutes, they don't teach you about the practice of that area of law or the interaction with the clients. So I think shadowing an attorney, seeing what they do on a day-to-day basis, could certainly paint a very clear picture of what it might look like if that's what you decided to do. So it's important to seek out mentors.
Can you tell us, this is also, I think, a very interesting thing for people that are listening. Can you talk about the kind of cases, say, you handled in the first 3 years of your practice, and those cases you also could handle now? And then let's talk about the cases you handle now.
Sure. So when I started with low-level misdemeanors, even traffic cases, speeding cases, or reckless driving, or maybe a DUI, driving under the influence, or a theft case, someone steals from Target. Still serious crimes, and depending on where the person finds themselves in their life, it's a very significant part of their life. Any conviction can be. Even certain speeding tickets can lead to loss of license. So I think when I started, that was kind of my niche, just to get a feel for going to court, negotiating cases. Obviously, the stakes are a little bit lower, but your experience is also a little bit lower, so it makes sense. For me, I was able to, in my first year of practice, second chair on a murder case with one of the partners of the firm at the time. So maybe my growth or my acceleration was a little bit quicker than others who might take a little bit longer to dip their feet into the water of felony cases. But I started, like most defense attorneys do, with misdemeanor cases.
And that was a good foundation for what you are doing now?
Yeah, foundation, confidence builder. Generally, you want to work your way up to having a trial, and it wouldn't make much sense that your first trial is a life case. You really want your first trial to be, it's always going to be important, but you don't want the stakes necessarily to overshadow the learning experience and the growth process. So yeah, it made a lot of sense at the time, and I would encourage other lawyers to not necessarily jump into a life case.
Right. That would be pretty scary. And I'm sure the people listening understand, you probably don't want to hire someone where your loved one is facing 50 years in prison or even 2 years in prison, and the lawyer, this is their first year of practice. That's sort of like they're practicing on you or your loved one. That's probably not a good idea. When you were in your earlier part of your career, you had a lot of experience in dealing with DMV matters, right?
Correct.
Let's talk about that for a second. What kind of DMV matters does the firm handle, and the kind of cases that you handle related to people that are losing their license or might lose their license?
So, as we all know, DUIs are very common in California. Every DUI triggers 2 separate cases, a criminal case and a DMV case. So for all the DUI cases you handle, you get experience handling the administrative side, which is the DMV side, or they're trying to take a license away. So I got a great deal of experience with DUI, DMV hearings. And then at the same time, I researched and learned and studied on other types of DMV suspensions where someone's at risk of losing their license, generally related to medical conditions like having a seizure, diabetes, loss of consciousness. And that became kind of a focus for me where I kind of tried to specialize and become an expert in that area. I found that not many people are able to advocate in that area and be successful. So I handled a lot of cases where my client was elderly and had some medical condition. The DMV got wind of it, sent him a letter, and said, we're going to take your license unless you can prove to us that you're not a risk to yourself or others on the road. And then I became familiar with the DME, or the medical evaluation side, to DMV hearings, which is very important.
And in fact, what I have found in doing this for 40 years plus, and you have found, I'm sure, is that when you're dealing with a senior citizen, among which I am now, and people come into our office and the DMV is trying to take away their license, and this is their last thing they can still do independently. It's one of the worst things you can ever see, to have to tell a 78-year-old, an 85-year-old who maybe has no traffic tickets in the last 20 years, a perfect driving record, that the DMV is going to yank their record because some young cop thought that he was driving or she was driving too slow. And we have to tell them if they lose the hearing, they won't be able to drive. Correct?
Yeah, it's a huge part of their connection to their freedom. Just like someone who's not elderly, their freedom can mean going into custody, but having the ability to drive, be it to the market, to a doctor's appointment, is really that last level of freedom that is in jeopardy. So I find that they are very sensitive and they're very desirous of a good outcome.
And we really work extremely hard with the doctors in winning those hearings. And I'll tell you something, when we can tell one of our clients, hey, guess what? We saved your license. I can tell you, every lawyer that works here, it's probably one of the greatest thrills we get. You might think, oh, the greatest thrill is when we get a not guilty verdict. And yes, that's exciting. But I'm telling you, this is such an amazing last thing that people can do. They can go to the grocery store. They can pick up their medication. They can visit their kids without having to wait for them to call. I mean, if you're listening to this show and you are either a senior citizen or you have a parent, I guarantee you can relate to what I'm saying. So if, God forbid, you ever have a situation where they're trying to take your license away or your parents' license away, just feel free to call us. Just go to our website, wklaw.com, and we'll be glad to help you. And we'll definitely speak to you on the phone for free to guide you. We'll always do that. So, Matt, can you tell us the kind of cases now you handle currently, primarily?
Primarily, I'm handling cases now where my client is facing, life in prison or something close to that. Normally sex cases, really any type of sex case, be it sexual assault, a rape case, child molest case, sexual battery. I handle other serious cases like vehicular manslaughter. But again, most of my clients, their exposure in terms of if they're found guilty at trial is in the range of 20 years or plus to life. So there's serious cases. But at the same time, I have a variety of cases. I'm handling school expulsion cases where my client is a student and being alleged to have sexually assaulted another student. So it's across the board, really, the type of cases I handle.
Do you primarily, if you had to pick primarily right now, you're handling mostly felony matters, right?
Right.
Among criminal cases, right? Because our younger associates are handling more misdemeanor cases, right?
That's right.
And where do you handle those cases? In what counties?
Yeah, throughout California. It's not just limited any longer to Orange County. Have cases in Los Angeles, Riverside, obviously Orange County, but beyond that too, really anywhere in Southern California.
Right. And obviously you probably imagine, if you're watching or listening to the show, can you imagine anyone could have a more pleasurable experience than to be able, as a father, to be able to interview their son who has achieved tremendous results and achievement as a lawyer? I don't know anyone else who's listening doesn't say, boy, you're a very, very lucky father. Anyway, thank you, Matt. We're going to come back after the commercial, and we got tons more to talk about.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV in court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When you are facing a serious criminal charge, it means you may be looking at many years in prison or doing up to 1 year in county jail. Most people do not know who to turn to in their time of need for expert legal guidance. What you do next can make the difference between ending up in prison for many years or having your charges dismissed and you going free. At this very critical time in your life, you need Wallin Klarich fighting for you. Wallin Klarich has 40 years of criminal defense experience, and they work very hard to do all they can to win their clients' cases. Wallin Klarich has a team of 10 criminal defense lawyers fighting for their clients every day. They help people with cases pending throughout California. They successfully defend cases dealing with murder, sex crimes, all felonies, as well as misdemeanors. Check out wklaw.com for some real client success stories. They offer a free phone consultation to answer your questions. Call them toll-free at 877-4-NO-JAIL. That's 877-4-NO-JAIL. They will be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
Okay, we're back. And Matt Wallin of Wallin Klarich, a partner at Wallin Klarich, is with us. And this segment, we're going to talk more of the human side, at least in part, the human side of practicing criminal defense. So Matt, when you first meet with a client's family and their loved ones in custody, whether they're facing murder or child molest or rape, some very serious crime, and the person's just been arrested, can you tell me what are your main goals in meeting with that family and why do you do whatever you do?
I mean, ultimately, I want them to leave my office feeling a little bit lighter than they did when they came in. So when they come into my office, generally they are confused. They lack direction, and oftentimes that's because they have no experience with this process, which could be pretty brutal. So I guess my main goal in the initial consultation is to show compassion, empathize with the client and their family, and of course obtain all the information I can, because it's hard to answer questions without a baseline understanding of what's going on. And I have to be comfortable asking hard questions and giving hard answers. Even if that answer is, we don't know yet, but we're going to find out. That's not always easy to tell a family that wants to know everything right away, but I'd rather be upfront from the beginning. And I find that that's the best way to approach it, is just to be honest and upfront, because these are human beings that need help.
Okay, so when a family comes in that situation and they have to decide like what law firm they should hire, what do you tell them about our experience and why it's a good idea to hire our firm as opposed to any other firm that may do DUIs or a general criminal law firm?
So I always tell them to do their own research, review, look at different rating systems that are available online, check out our website. And then I just speak to our firm's experience, the way that our firm is structured in terms of a team approach. I talk to them about our experience in that particular court with that type of case. You just want to make them feel comfortable. I never really try to, I'm not a salesman, so I'm not trying to sell anything. I'm just trying to let them know what our approach is going to be and let them know they have to feel comfortable and to make them feel comfortable.
Sure. But one of the reasons that people watch these kind of shows is to get knowledge about how to select a lawyer. So for example, if you called our office, a person called our office and they were they were wanted a lawyer to represent them in a car accident case because a family member was brutally damaged and the recovery could be millions of dollars. Our law firm, if we took on that case, could stand to make hundreds of thousands of dollars in legal fees. But we would never do anything like that because we are not qualified to handle that kind of case.
Sure, first thing I tell them is that you need to make sure the attorney that you hire, that the focus of their practice is that area of law. It seems like a kind of a no-brainer, but if that attorney is not really specialized or practice exclusively or almost exclusively in that area, that's a red flag immediately. You also want to make sure the attorney's familiar with that area, that locality, because each jurisdiction, each court is different. So I think knowing the type of case, the area of law, and the actual physical location, all those are important factors.
One reason that so many people call us when a person's accused of a sex crime is because literally for my entire career, we have represented people accused of that crime. And the way that is because for 35 years now, we've represented the California Teachers Association. And any teacher who gets accused of a crime, and unfortunately, whether it's true or not, 80 to 90% of the crimes that teachers get accused of because they're dealing with students is something to do with abuse of a student. So we've literally handled over 1,000 cases representing teachers and thousands more of people, regular people, doctors, lawyers, construction workers, plumbers, who are accused of a sexual crime. So of course, when you have that many years of experience, it would probably be a good idea to, at very minimum, call us for guidance because of that experience. You would agree on that, right?
Yeah, absolutely.
Yeah. So when the family comes in and they say, we want to hire you, what are the first steps you take in trying to figure out how you're going to help this person?
Well, first thing I try to do is gather as much information as I can, where they are in the process. There's so many different stages to a criminal case, be it before charges are filed, after, where's the investigation. So I like to run a parallel investigation, which means engaging with a private criminal defense investigator and basically run our own investigation, interview witnesses, go to the scene, obviously speak to the client, and again, do a similar type of investigation that law enforcement is tasked with so that we have the information we need to begin to discuss the case with the district attorney. So I guess step one would be gather facts and then determine what kind of the timeline and blueprint is for the case, be it having my client evaluated by a professional, a doctor, again, retaining experts, doing investigation, beginning negotiations with the prosecutor's office. There's a whole list of things, and it's, again, very case specific and process specific.
And another question that often comes up is, well, can you go to the jail and talk to the client freely without being worried that it's being tape recorded and that they can use that evidence against the client?
The answer is yes. A side note is that anytime a loved one's in custody, and if they're calling family members, that's of course not privileged. So you have to keep your communications very limited in terms of, hi, I love you, and no discussion factually at all. But yes, we're able to, as attorneys, get a private attorney booth and have non-recorded attorney-client privilege confidential communications, which is crucial. And during the pandemic, certain jails have allowed for attorney phone calls on cell phones to be also given the attorney-client privilege, where you put your number on a list. So even if you can't get to the jail, your client can call you and you can speak in confidence.
Can you also talk about, because many of the cases that you handle primarily are one minor, let's say a 14-year-old girl or boy, is accusing a teacher or a doctor during an examination of sexually touching them inappropriately sexually, right?
Yes.
One against one.
Common fact pattern.
Right. So you talked about the possibility of getting an expert. Can you tell us what kind of expert you're talking about, and how could that make the difference in a case, in a case like that?
Generally speaking, in child molestation cases, these are crimes or alleged crimes that occur in private. There are no witnesses. There's my client, and there's the complaining witness or the accuser. So when you have a situation like that where there's no independent eyewitness, there's almost never any forensic evidence. Depending on the conduct that's alleged and whether or not the alleged victim was even medically evaluated, there's very likely no DNA or forensic evidence. So what you have is a statement from the alleged victim, which there's a jury instruction on this point that shocks people, that the word of the alleged victim alone is enough to convict one of my clients. So that shocks people. They'll come to my office and say there's no evidence, and I'll have to break down for them that I understand what they're saying, but in fact there is evidence. The evidence is the statement of the alleged victim. So a way to bolster our position when you can't prove a negative, you can't always prove that something didn't happen. There are times when you can try to raise that as a defense in terms of it wouldn't be possible that it occurred at the time or in the location alleged. But in terms of seeing a medical professional, it's called a psychosexual evaluation, where a doctor can evaluate, review all the evidence in the case, and then do.
Oh, okay, we'll conduct that in a second. Melanie, how can we help you today?
Hi, I just have a quick question for you guys. If I'm accused of domestic violence and my husband doesn't want to testify, can I still be convicted?
That's a good question. You got it?
I mean, the answer is yes. The question was, can she be? Yes. It will be challenging, and it's fact specific and evidence specific, but the answer is yes. A crafty prosecutor would be able to proceed without the cooperation of the victim, given certain evidentiary standards that have to be met, because generally hearsay is not admissible. But it's not uncommon for a victim or alleged victim to back out or to change their mind or recant, and that doesn't mean the case will immediately go away. It depends.
But there is a crazy law that actually could help our client in domestic violence cases and in sexual abuse cases. If the alleged victim is subpoenaed to testify, like most people, they must come to court. And if they don't come to court, they can have a warrant issued. But in other cases, if a witness comes to court and it's not a sexual abuse case or a domestic violence case, and they're asked questions and they refuse to answer unless they have some kind of privilege, they can be held in contempt and put in jail until they answer the questions. With a sexual abuse case, if they refuse to answer, they're not allowed to be put in jail. There are other things that can happen. So that makes it a little dicey in a domestic violence case for the DA, because he may have a completely uncooperative victim. However, as Matt said, that doesn't mean it's still not a difficult case. It doesn't mean that they still might not be convicted, but it does give us a little more chance if the alleged victim decides to do that. And many people want to recant, as Matt said. Now they hear, oh my God, he's facing prison, he loses his job. Sure, Many times spouses, significant others, when they hear the consequences, they say, oh, he's not such a bad guy, he won't hit me again. Well, that may not necessarily be true, and the DA believes he will hit you again.
The state that's prosecuting, it's not the victim or alleged victim. So even without their desire or participation, the state could still proceed and try to seek a conviction.
Exactly. So did that give you some information there?
Yes, it's very informative. Thank you.
Thank you very much.
Thank
Okay,
you.
Matt, let's talk more about that examination you're talking about. So you have the defendant, the person accused, see an expert medical doctor or a psychologist.
Exactly. So that doctor will meet them either in custody or if they're out of custody, meet with them, do a clinical interview, a psychosexual interview where they ask hundreds of questions, and they have them perform hundreds of tests to determine whether or not they have a profile or a sexual interest in children. An important fact in a case like this, where the allegations are of sexual conduct with a child, showing that your client doesn't have that profile, essentially is not a pedophile, is not attracted to minors, can mean the difference between being found not guilty or guilty when it's someone's word versus another's.
Exactly. So the jury, who obviously, I think one thing's important to add, Matt, is the jury who'll sit in judgment does not know the defendant, does not know the alleged victim. They don't know in the past. I mean, we try to get in evidence if the alleged victim has lied in the past, we try to bring that in. Sometimes the judge doesn't allow it. So they're really stuck, so to speak, who to believe. So if we can call an expert doctor who is credible and the doctors we call are credible to say, I've checked this dude out, he definitely doesn't fit the profile of other sex offenders. So they're basically rendering an opinion that he wouldn't do this act. And the jury only has to believe, they have to believe his guilt beyond a reasonable doubt. So I have had cases in the past when the case was over, jurors would say to me, why did you vote not guilty? And they would look me straight in the face and say, I just couldn't decide. She was credible, but your client was credible. But why would she lie? I know why he would lie, but ultimately the doctor said he wouldn't do something like that. And literally it was as basic as that. And they found not guilty. So now you know why one of the tools we use in our cases very often is that expert, which is something that a lot of lawyers don't know about. And it can be the difference between your loved one going to prison for many decades or walking out free. So anyway, that's definitely something important, right?
Definitely.
Okay. Can you tell us just one example of probably one of the cases you handled that personally was very, very rewarding to you? Professionally, and when you were over with the case, that this is something why I went to law school for.
One that comes to mind is, I don't want to, for confidentiality purposes, to name the school, but a major university, a student was a senior, an incredible student, on his way to graduate his senior year. He started going out with a girl. They started to have a sexual relationship. That relationship became physical, consensually, where there was choking going on. And at some point in the relationship, she told the school that she was being abused or sexually assaulted. And basically my client's entire life and their family were flipped upside down. And in that case, it was heavily litigated, but ultimately my client was acquitted or found not guilty, and he graduated. And that's just a case that comes to mind that occurred recently, a sexual assault Title IX case.
What does Title IX mean for people that don't understand?
Title IX basically is, the way you see it manifest in terms of the way I handle it, is whenever there's an accusation made on campus of some sort of sexual assault between students, the Title IX office, which all schools have because they receive federal funding, will take it up and basically become like their own police department and do an investigation. But they're not police officers, they're not detectives, they're not prosecutors. They're only simply trained in these sexual assault cases, and I find that they're often extremely biased and short-sighted in the way that they approach the case. So that's where you see Title IX is sexual assault or domestic violence between students at a college.
I see. Okay. So we've handled many cases of that exact nature, and you've handled many of those cases, right?
Yes.
In fact, not just all over the state, I think, right?
Yeah, all over the state.
Yeah.
Correct.
Okay, the last topic I want to talk about in today's show, and obviously I'm going to bring you back for other shows because so much information, is when someone gets arrested for a domestic violence, people do not understand what are all the consequences if they're convicted of domestic violence. Why don't you explain what you tell a client who's coming in and saying, oh, it's no big deal. What are the real consequences?
I try to explain that the legislator or that there's statutes for certain crimes that designate certain punishments that can't be changed. And I always reference DUI and domestic violence. So because the legislators have put in place these automatic punishments, it means that if you are convicted, meaning you plead guilty or you're found guilty, there's certain punishments that are non-negotiable that you must do or you must serve. And one of them is a 52-week batterers treatment program. So that's one of those things that if you're found guilty of domestic violence, it's just an automatic that you must do. Oftentimes, domestic violence, there's protective orders which separate the victim or alleged victim and the suspect or defendant. So probation is also a part of that. So those are some of the most common terms you'll see is some sort of treatment or class, protective orders, and a probationary period. And then, of course, there's the issue of potential custody time.
And when you say protective orders, again, just so people understand, so that means that the defendant, there's an order that he cannot come within a certain distance of the alleged victim or the victim?
That's correct. It's a no contact order, which means just that no contact, direct, indirect, through a third party, electronically. So except through your attorney, no communication between the parties, which can be devastating if raising a child together, living in the home together. Comes back to that issue of this can occur even if the victim is not desirous of prosecution. They can still.
So how long can that protective order go for? Are you talking about like a month, or are you talking
the whole pendency of the case, number one, and then beyond that, it can be extended up to 10 years.
So if the person walks into court and pleads guilty, if the person walks into court and pleads guilty to domestic violence and doesn't hire a lawyer, that consequence can happen, and will he even know about it?
I mean, he'll have to be personally served with it, so I would sure hope so, in the sense of, as a part of the resolution, be it with the court or the DA, he needs to be told that one of the consequences or terms is a no-contact criminal protective order. He needs to be told who the protected party is and the length or scope of that protective order. So yes, obviously that's something that if I'm negotiating a case, knowing who my client is, who the alleged victim is, and their relationship, it has to be a part. That's one of the many things that has to be a part of the negotiations in order to make sure that the outcome is favorable for my client.
And so I have to think that the main reason in hiring us in cases like this is to do everything humanly possible to avoid that conviction.
So yes, especially for domestic violence cases, that's correct.
And part of that, I assume, would be if the alleged victim wanted to recant their prior statement to the police. That could be critical, right?
Of course.
And if in fact that person wants to recant, they can come into our office and they can give us a statement and we get an investigator. Is that how it works?
That's generally how we would do it. Yeah, we would have an investigator take a statement. And again, the district attorney's office is generally not going to have communication with any of those parties. So they are going to take a back seat when it comes to that. So we're the ones that have to obtain their lack of desire for prosecution and make it known to either the judge or the DA or both.
Okay. Matt, I want to thank you for coming on the show. This has been one of the highlights of the entire 10 weeks, just to be able to question and get to know my own son a little better. And guys, he'll be coming back for another show. And next week we'll have another show. And I want you guys to have a great week. Remember, legal knowledge is power. Have a great week.